Reif versus Nagy. Go ahead, please.
Good afternoon, Your Honor. Thaddeus Stauber on behalf of Mr. Nagy. This case arises out of a horrific set of historical circumstances. There's no question about that. But what is really at here is, are there triable issues of fact?
What are the triable issues of fact in this case?
First and foremost, did Mr. Fritz Gruenbaum own the artwork in question? Second, did...
Well, where did the artwork come from?
We don't know that, Your Honor. That is a question of fact that needs to be resolved.
We know that in 1956 it appeared in a brochure, correct?
Excuse me, Your Honor?
It appeared in a brochure in 1956?
Yes, it appeared in the catalog in 1956.
So how did Kornfeld get the art?
As Mr. Kornfeld testified in both provided documents, he obtained the artwork from Matilda Lukash. And in addition to his testimony, which was put forth in the Bacalar case which preceded this, he testified that he had multiple interactions with Matilda Lukash. In addition to that, which was entered into this record, I direct your attention to the record on appeal 2450. There is extensive communications between Mr. Kornfeld and Matilda Lukash regarding her interest in selling a number of artworks, including Sheila artworks.
So it's your position that the sister-in-law had good title to the art?
It is our position that there is a material issue of fact as to whether or not Matilda Lukash rightfully owned the artworks, possessed the artworks, and then it's a question of law whether she had the right to sell them. But first is a material issue of fact.
What's the evidence that suggests that the sister-in-law, in fact, had these two works of art?
Thank you, Your
Legal
Honor.
title to it. Legal title to it.
Yes, yes.
What evidence do you have?
If you look at the expert report of Ms. Lori Stein, who was the advisor to the Smithsonian, if you look at the expert report of Lynn Nicholas, who was the advisor to the President's Commission on Holocaust Assets, and if you look at the expert report of Sophie Lilly, who was advisor to the Jewish community of Vienna, each and every one of them examined the record. And I direct your attention particularly to record of appeal 2451, record of appeal 246 to 2471. In those documents, Matilda Lukash says, I have Sheila's that I am interested in selling to you. She goes and visits with Eberhard Kornfeld in person. Eberhard Kornfeld documents in writing that he has received Egon Sheila's from her. He then provides an entry in his inventory after the sale in 1956. If you look at Exhibit 2470, Record of Appeal 2470, there's an entry 36514, 36522. These are Egon Schiele works which bear a title that lines up with the artworks here in dispute.
Counsel, assuming that she did transfer them to him, what evidence is there that she had good title to them in the first instance, that she was able to legally transfer them?
Thank you, Your Honor. If you look again at the record, there is evidence in the record citing to Lori Stein's report, Exhibits 13 to 14 and Exhibit 18, Record of Appeal 2248 to 2298 and 2337 to 2395. In those historical documents, Ms. Lukash and her husband Sigmund are documented as owning Sheila artworks, which they are able to take out of the occupied area in 1938. So there is evidence that she was able to take her property, including Sheila artworks, out, and then they tie that up with the evidence that you have from Mr. Kornfeld receiving them from her. Our problem...
Help me out in terms of the number of paintings she had. My understanding was that she had a relatively small collection herself. And the fact is, what's your statement that these two paintings in particular were part of that collection, correct?
We think that the evidence demonstrates that those particular artworks, yes, were part of her collection beforehand. But the truth is, I don't know the answer to that question, Your Honor. The truth is, this is a case which lines up with Dr. Petropoulos for the plaintiff, a well-qualified expert, 3 experts for the defendant, all themselves well-qualified, who looked at the evidence. It's a historical document case. In addition to Eberhard Kornfeld's testimony, And the role of the judge in this particular situation, as eager as he may be to bring justice for the horrors, is not to serve as the fact finder. It's not to weigh credibility.
The judge relied on the HERE Act. Is there any case other than this one applying the HERE Act outside of a statute of limitations or laches to sort of create greater rights or presumptions for potentially Nazi looted art? Or is this Judge Ramos sort of trying to move the law?
This is Judge Ramos trying to move the law, Your Honor.
Are you suggesting that the HERE Act has absolutely no application?
No, I think the HERE Act does have application.
So could the HERE Act inform Judge Ramos in making his decision?
I think the HERE Act both informed Judge Ramos and it informed us as the plaintiff, the defendant, I'm sorry, because the HERE Act was passed during this case. In April of 2016, when the HERE Act was first offered, it allowed laches as a potential defense.
Putting aside the laches issue, on this, putting the timing issue, what's the relevance of the HERE Act to the substantive claims? Does it alter anybody's burden of proof in this case?
It does not. It does not alter the burdens of proof. It doesn't alter the evidentiary standards. It doesn't say that we default to a system like was used with the German art loss database or the Viennese Austrian panels in which we don't have trials. In fact, it says just the opposite. It encourages us to bring these cases out to light, not use technical defenses to have these cases defeated, and to look at the historical merits of each particular case. That's all we're asking for here, Your Honor. We're asking for a remand to have a trial.
What do you make of the email?
What significance do you give that the fact that defendant was relying on the federal court's decision about estoppel in this case, and to some degree was conceding the provenance of the work then?
Your Honor, in filing the collateral estoppel argument, which this court denied, which this court said, you do not collectively look at these cases, you individually look at these cases. So purpose for collateral estoppel, all the defendant was conceding at this point is, we have a similar fact pattern. We have a relevantly similar fact pattern. We have the same conduct as we had before. The court denied that, sent it back.
You don't think any concessions were made about the provenance of the work in that?
No, not at that stage, Your Honor. I don't think any problem, but to the extent they were, this court emphatically told us that you individually look at each individual work. And that's exactly what we did. Contrary to what happened when we came back, the plaintiff immediately submitted a motion for summary judgment, relied completely on the baccalaureate record, submitted the expert report from Dr. Petropoulos from 2008, which was not even directed to the two artworks at issue, but was directed at the baccalaureate artwork, and relied solely upon that to use it as a sword, and therefore shut down an opportunity for a trial. That's all we're asking for, Your Honors.
Thank you.
Does the panel have any questions?
Yes. How about your name, and then I have a question.
May it please the court, Raymond Dowd for plaintiff respondents.
Mr. Dowd, same question, putting aside the timing, putting aside the statute of limitations, what's the basis for reading into the HERE Act sort of some latitude about how we trace the provenance here?
We don't need the HERE Act, Your Honor. We don't need the HERE Act to win this case.
So how do you
We have the
prove
facts.
not that this was Nazi stolen art, because I think your burden's different. How do we tie these particular paintings to Mr. Gruenbaum? Not to prove that other people in the chain had bad title.
Well, we do it the same way Judge Pauley did when he made that finding in Bacalar that all of these artworks were Gruenbaum's. We first look at the Jewish Property Declaration, and it identifies 81 Sheilas that belong to Egon.
Are these
to
paintings on
Gruenbaum.
that list?
Dead City 3 is.
Okay.
And we can tie up and match up a whole bunch of other ones, and I'll tell you how. What we have is two documents, one from 1925 and one from 1928. 1925 is the Vertel Gallery catalog, and in 1928, it's the Hagenbund Gallery catalog. And Jane Collier, in her testimony in the Bacalar case, did a match for match with the 1956 catalog to show that Dead City 3 and many of these other artworks matched. So we were able to tie together these 63 artworks. Then Justice Ramos looked at the fact that Kornfeld admitted it, the fact that, and we differ with Mr. Stauber, we are certain that it's a judicial admission because he said it was the same provenance that Judge Pauly found.
Counsel, you're referring to the answer with counterclaim?
Yes, Your Honor. And the motion before this court that preceded this, where Mr. Stauber argued it's the exact same provenance. We want you to follow Bacalar, is what he said. These all came from Gruenbaum.
I'm not going to get all their names right. Several experts who offer alternative explanations.
That's
But one
complete.
second, let me finish.
Sorry.
How do we, or how does Judge Ramos reject those as a matter of law? Why don't those raise issues of fact? They suggest there may have been some back deals, maybe some people moving assets out of the country with favorable art dealers working with them. Why don't those just raise an issue of fact?
Very simple. We look at the evidence and we look at what those expert reports say. So the evidence at page 153 of the record, we have a Jewish property declaration that is dated June of 1939. There's two stamps on it. One is Gespert and one is Erledigt. It's signed by Lily Gruenbaum pursuant to a power of attorney that was given by Fritz while he was in the Dachau concentration camp. And those two stamps are translated as done and restricted. And they were done by a Nazi official. This is explained in the rebuttal report of Dr. Jonathan Petropoulos, which shows that there's no issues of fact possible. Those alternative theories rely on a post-Kristallnacht transfer, which has never happened in history, according to our historian experts.
Well, Counselor, assuming that
The
all
alternative speculative theories, sorry.
assuming that you identified and you matched these paintings to show who the original owner was, then we go into the, is that her name, Lukash, the sister-in-law?
The sister-in-law,
She would have to have legal title.
complete identity theft to start with, A.
Okay.
And I think the panel asked 4 times, how could she possibly have legal title? And you didn't get an
The
answer.
adversary seemed to say that there's record to show that. I don't know what's in the record that he's referring to, but is there anything there to show that
There's
she?
nothing there. There are
Okay.
some forgeries. None of them have to do with these paintings, these artworks. There's no invoices that tie these together.
She was the one who sold these paintings to Kornfeld.
Absolutely not. It's not true.
Well, that's one of the theories, and for.
I mean,
It's an alternative theory.
Assuming that she did, I mean, but there's no record to show that she had legal title.
Even if they won on that, she would have no good title. You couldn't possibly win.
Okay.
You have 3 minutes.
Counsel, one of the bases of Judge Ramos's decision was an email from the Kornfeld Gallery, which referenced the works as a collection from Fritz Gruenbaum, then to the widow, and then to the sister-in-law. Doesn't that have significance here as to whether or not first a prima facie case has been made out?
Your Honor, that has the same weight to be given to it as Kornfeld's testimony was to be given to it. What Judge Ramos did is picked and chose. He said, I'm going to accept that representation from Mr. Kornfeld, which comes in 2004, but I am not going to find true that he actually bought the artworks from Matilda Lukash. I'm
Okay,
not
but-
going to
but
believe,
then
so he's not in a position to weigh credibility.
So fair enough. So Kornfeld buys the artwork from the sister-in-law. Can she pass good title to?
She can pass good title if she owned the artworks. And our position is, in the record, there are multiple representations, historical documents, which all the experts looked at, and three of our
Which
experts
historical
relied on.
document establishes that Lukash owned these two contested pieces of work?
Yes. If you look at Ms. Lori Stein's report.
Give us the page in the record.
Yes, Your
Not
Honor, I
opinion.
will.
Not opinion, not
Not opinion.
but
Record
a
on-
historical
look-
document.
Look at historical documents, 2248 to 2298, and 2337 to 2395. These are documents which show that in 1938, Matilda Lukash is bringing out at least a number of Sheila artworks that she has in her possession prior to the time that the tragedies happened to Fritz and Lily Gruenbaum.
What
In
proof
addition
is
to
there
that,
with these two paintings versus that she just brought some paintings out?
that's a good question, Your Honor. No more than the representation by the plaintiff that Fritz Gruenbaum owned these artworks because he had submitted an inventory that included a collection of Sheila works.
What
So
about
we're
the
both in the
admission-
same position, quite
What
frankly.
about the admission about Dead City, and that was part of the same collection as the other paintings? And Dead City has been shown to have belonged to Gruenbaum. What about that connection?
There's no question that Dead City belonged to Mr. Fritz Gruenbaum.
And weren't there
But Mr.
concessions
Eberhard
made
Kornfeld
that
makes
that was
us-
part of the same collection?
No, Mr. Eberhard Kornfeld makes a connection later that he believes that these artworks trace back from Matilda Lukash to Fritz Gruenbaum. That doesn't mean that it is true. That doesn't mean that it's correct. That means that his credibility is at issue. That means that for this particular artwork, on this same evidence, must be submitted to a fact finder. Judge Pauly, yes, Judge Pauly is finding a fact that that particular artwork at issue belonged to Fritz Gruenbaum. He did not find that all artworks belonged to Fritz Gruenbaum, and then when he did, he found that it was not stolen by the Nazis. And then he made a finding of latches. So even if this court does not want to allow to go to trial an important factual underpinning that needs to be addressed, at a minimum, Mr. Nagy still has the defense of latches.
Let's
And
talk
that
about-
issue was shut down by the trial court.
I apologize for asking a question with the red light on, but let's talk about that for a minute. How was Mr. Nagy prejudiced by plaintiffs bringing this action with all the sort of machinations that the client took, that he was clearly aware that plaintiffs were making claims with respect to the artwork?
Yes, he was certainly aware that the claims were going to be made, Your Honors. But we have the same situation. We're put in the situation where Matilda Lukash has long since passed away. The plaintiffs have taken no action to attempt to get the work. He went to the Art Loss Register and asked them, the standard bearer for determining if we have stolen artworks, and they gave him a written opinion that the artworks were not stolen and that there were no valid claims. In addition to that, he didn't stop, but he hired independent
Follow up,
experts.
Because I think my question will build on my colleague's question. I too apologize, the light's on. Are you saying that laches doesn't just involve when the claim was made against your client, but whether the delay in coming forward, claiming this is lost art, has caused witnesses to disappear or pass away,
Yes.
even before your client took title?
Yes, absolutely. The fact that somebody is saying, I'm going to make a claim, I'm going to push, especially after we have a ruling from a federal court on essentially similar facts.
Really? You think the facts are similar? You don't think that in that case, the collector, as I recall, had the piece of work since the mid-'60s? Whereas,
Your Honor, yes. So
your
Mr.
client got the work much more recently?
He did get them much more recently, and he bought them from the Rubin Estate here in New York. He bought them from Sotheby's after they've been after the public. He's
Clear
in no.
knowledge at the time he bought them that there was a cloud on the title, unlike the federal case. Isn't that a big distinction between the two cases?
Because someone says, I'm going to make a claim, but they haven't pursued those actual claims. There's artworks here at Oberlin College in Ohio with the similar story. There's artworks right here in New York at the Museum of Modern Art with a similar story. Cases haven't been brought against those artworks. Why do we select out an art dealer who chooses to buy a work for fair market value, stops, checks with the art loss register, retains independent experts who have in the past represented the Vienna Jewish community, the Commission for Art Recovery, the United States, the Smithsonian, the author of The Rape of Europa and delegation to the Terrorism Declaration, and checks and brings all those in. And they
Counselor,
give him an
the,
opinion that they're not stolen artworks.
The pages you cited before concerning Lukash, I mean, is there something in those, in the record to show that she had legal title, not possession? I don't want to know about possession, I want to know about legal title, that the sister-in-law had legal title to these two paintings. Do you have any of that in the record?
I have in the record, Your Honor, that Mr. Kornfeld says he purchased them from somebody who brought them to him, not just somebody, but Matilda Lukash, somebody he had dealt with in the past, that he paid a fair price for them, and that she had them in her possession at the time. That is, by definition, makes her a lawful owner of the
We have
works.
to follow the legal ownership of these paintings, not somebody who maybe found them or stole them and then sold them. I mean, it's got to be legal title. I mean, do you have anything in it to show that this sister-in-law had legal title?
First, Your Honor, we have to establish who exactly had these works prior to the outbreak of the war. That is a factor in
Was
dispute.
anything in the record, yes or no? If not, in the...
Yes, Your Honor, there is in the record. The record is that she had the artworks, that she entered into the
Not
transaction
possession,
with
legal
them.
title.
And I'm saying that at that point in time, the fact that she had the artworks in her possession, arguably in her possession, no different set of facts than what
All
the
right.
plaintiff claims regarding Mr. Fritz Gruenbaum.
We have
And our
your point.
position
No, you
is-
finish your sentence, go ahead.
Our position is, as you can see from this particular hearing, these are very volatile issues. The purpose of the HERE Act is to say to us, let's bring these cases out into the open. Let's have a trial on the merits. That's all we're
Oh,
simply
I've heard
requesting
that
here.
she has possession, that she had possession. I'm talking about any proof to show legal title.
There is no
You're
more
going
proof
into
here, Your Honor.
possession
with-
Over and over again.
That question goes the same to Mr. Fritz Gruenbaum and his heirs' claims, Your Honor. And that's why we have experts, both all well-qualified experts, who are on diametrically opposed sides of this. And that's why these cases go to a fact finder, be it a bench trial or a jury
You need an expert to show
trial.
legal title? You need an expert to show that?
You need an expert to
I mean, it's
establish.
documents, it's official documents you have somewhere to show that she actually purchased this, or maybe her sister-in-law gave it to her under a will or something.
That's exactly why, Your Honor, in one hand, when Judge Pauley was faced with this, after doing a trial and entering into evidence records, he found that laches was applicable.
All right, excuse me, Judge Tom, anybody else have any other questions? All right, thank you.
Thank you, Your
Thank you
Honor.
both. By the way, we used to have a colleague once who didn't like the light system, and he said that he wasn't going to start asking questions before red light went on. I tried not to do that, Your Honor. No, it's a very, very interesting case. Thank you both. Telex New York versus 60 Hudson.